Welcome to the third and the final lecture covering previous year questions from the topics Judiciary and Bodies from the years 2011 to 2021 for polity for the Civil Services Preliminary Exam. Now, I originally had planned to do this in two lectures, but given the fact that there are about 25 questions in total, it makes more sense to just finish it off in one lecture so that you can revise quickly and in a more comprehensive manner. Now, between these two topics, it is judiciary which has been asked in the most controversial and in the most tricky manner in the exam. In fact, it is a matter of great interpretation and also a play with words as far as the judiciary is concerned. So we have to keep that into mind. In case you haven't already done so, please watch the first 16 minutes of the first PYQ video wherein I have discussed the logic, inference, rules and other tricks that can be used to solve polity questions for your upcoming prelims exam in 2022. As far as judiciary and bodies is concerned, on an average you can expect about 3 to 5 questions in total as far as this particular topic is concerned. Let's begin with the first question. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in the police station and not in jail. The second statement is, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Now, this seems like a question which may request you or which may hint towards you understanding criminal procedural law in detail, but actually that's not the case. This question can be solved through a simple application of separation of powers, which is rule number 3. Read the statement carefully. Judicial custody means an accused is in the custody of the concerned magistrate. This means the judiciary has issued an order to keep a person under arrest under a judicial officer, and then this person who has been arrested is now kept in the police station, not in jail, is not kept in the jail but is kept in the police station, right? The police station represents the executive. This is the judicial arrest and you are placing the person in the hands of the executive. Seems a little odd. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. During such a judicial arrest, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Now think about this. If the person is under judicial arrest, that means you're under the larger AGs of the judiciary, and the police officer concerned, which is the executive, cannot talk to the person under custody without the permission of the concerned judicial magistrate or the court for that matter. If you see, both of these statements tend to have a little bit of a contradiction. If you were locked up in police station, right, and not in jail, and the police officer is not allowed to interrogate you while you're in the police station, which is under the supervision of the police officer, how will you exactly execute this, right? So the second option seems correct, because here the judicial custody is still under the management of the judiciary and the executive is stopped from interfering beyond a point and without prior approval. So the second option is correct, the first option is not. Both of them are contradictory in nature, so both cannot be correct at the same time. The answer here will therefore be B, which is 2, right? Now, the next question. With reference to India, consider the following statements. When a prisoner makes a sufficient case, parole cannot be out denied to such a prisoner because it becomes a matter of his or her right. Because it becomes a matter of his or her right when the prisoner is making a sufficient case. State governments have their own prisoners release on parole rules, right? State governments have their own prisoners release on parole rules. Now, let us see if we can try to put some logic to this, because it is very difficult for aspirants to ordinarily have academic knowledge about this. What we know is parole is when somebody is let go of jail earlier than the sentence was supposed to be finished on a number of reasons, including good behavior and contributions and so on and so forth, right? The option says, as long as a prisoner has made a sufficient case, as long as the person who's in jail has given a good reason for the person to be let out early, then you cannot deny it and it becomes a matter of right. Now, parole is essentially a quasi-judicial decision. You have to decide whether the grounds are sufficient enough, whether the actions of the prisoner are sufficient enough. Just because somebody has made a good enough case does not necessarily mean they're entitled to something. That means that if a defense makes a good enough case that their client has not committed murder, then the client has not committed murder. It is never about just that. It always has to be decided by an authority after hearing both sides, after hearing both sides to the matter. And parole can never be a right, because if that's the case, then everybody would be let out early and the entire process of law would seem a little objectionable. So this is definitely wrong. Second, state governments have their own prisoners release on parole rules. Now think about it. There is also a degree of contradiction between both of these statements. If state governments have their own prisoner release on parole rules, then you cannot have a universal statement like this making it a national right for every prisoner. So either the first statement can be correct or the second statement can be correct, right? Now think about what you know about prisoners and parole rules. You know that law and order is in the state list. Now if law and order is in the state list, that means maintenance of law and order in prisons would also be in the state list. Think about officers you know who are deputed to prisons, right? You would often know that jails are maintained by the state government, right? And therefore this sounds like the correct option because law and order is in the state list. So B is the right option, 2 only. There we go. Now, this is a question which has given a lot of us far too many sleepless nights, and I must also admit I would have also marked this question wrong as per UPSC. But now it is my job to justify and to prove to you why UPSC's answer is the correct one. Okay? Any retired judge of the Supreme Court can be called back to sit and act as the Supreme Court judge by the Chief Justice with the prior permission of the President of India. That's the first statement. The second statement is a High Court of India has the power to review its own judgment as the Supreme Court does. Now, both of these statements are not related to each other, so let's look at them independently. Usually, a collegium recommends a name to the President and the appointment of the Supreme Court judge is done. Now, we're talking about appointing retired judges in case there is a vacancy or a shortage of judges or there's a increased workload of cases. The retired judge of the Supreme Court would have at some point of time anyway satisfied the collegium process, would have anyway satisfied the seniority in the collegium process and all of that, which means you don't need the collegium process again because you need an immediate appointment for a shorter period of time. So, the Chief Justice of India can directly appoint upon recommendation to the president or with the prior approval of the president. This is logically the right answer, the right option. Second, this is where the controversy lies. A high court in India has the power to review its own judgment as the Supreme Court does. Now, most of us have thought that the Supreme Court is the court of record, and the Supreme Court and the High Court is also a court of record, and you have the power to review your judgments. Now, understand this. Review means two things. X case happened, Supreme Court gave judgment A. A few years later, Y case happened, Supreme Court gave judgment B. Can the High Court also do this? Yes. What is the UPSC saying? X case happened, Supreme Court gave judgment A. You are unhappy with A's judgment on the X issue. You ask the Supreme Court to review the same case again and see whether the judgment was right or wrong. What this option is referring to is actually a review petition, is actually referring to powers of a review petition. Can the same case be reviewed again? To that extent, review petitions cannot be filed in the High Court, they can only and only be filed in the Supreme Court. From a procedural standpoint, it's in the Supreme Court rules also versus the High Court rules. The Supreme Court has 2 layers of review, the High Court only has 1 layer of other judgments, and also at the same time you require a certification of the senior advocate, but this is all in the Supreme Court rules, they're too technical for you to know. The simplest explanation here is this: they are referring to review petitions. The simplest meaning of it is that they are referring to review petitions, and that is why the UPSC has marked this option as wrong and therefore has given the answer as 1A only. Okay, surprising as it is, but such is the case. Life is strange. Question number 4. Consider the following statements. Now the easy part begins. The Constitution of India defines basic structure. Apply the trick that I have told you. If it says defines, it has to be defined in black and white explicitly as it is. In terms of federalism, secularism, fundamental rights and democracy. The Constitution of India provides for judicial review to safeguard the interests of, safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Provides for judicial review. Defines basic structure. Neither basic structure nor judicial review is anywhere defined in the Constitution. The answer is a simple D. The trick was whether it is defined in the Constitution or not. Simple question. This is not a problem. Consider the following statements. The 44th Amendment of the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. The Supreme Court of India struck down the 99th Amendment as being violative of the independence of judiciary. Now the 44th Amendment, we remember this, 4 plus 2 is equal to 6. The 42nd Amendment is 1976. 4 plus 4 is 8. So 44th Amendment is 1978. This is the post-emergency amendment, right? Now the post-emergency amendment is to undo the misdoings of the emergency. Now this is supposed to be the good amendment. 42nd is supposed to be the bad amendment. So that around that time is the bad amendment, right? Now see, the 44th Amendment introduced an article placing the election of the Prime Minister beyond judicial review. This is incorrect because this was done through an earlier amendment. This was not done through the 44th Amendment. The 44th Amendment was supposed to bring back and undo the wrongs that happened. I think it was the 38th or the 39th Amendment. So this is definitely wrong. The Supreme Court of India struck down the 99th Amendment as being violative of the independence of judiciary. This is the NJAC judgment that we know, that the National Judicial Appointments Commission, which was inserted to introduce an institutional mechanism headed by the Chief Justice, comprising of two senior Supreme Court judges, the law minister, and two jurists nominated by the Prime Minister, the leader of opposition, and the Chief Justice, to decide on appointments and transfers to the Supreme Court and the High Court. That was struck down because it was violating independence of judiciary, which is basic structure. This is correct. The correct option is B, 2 only. Okay. Now, 6. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally valid. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Again, very simple question. Let us see. No High Court shall have the jurisdiction to declare any central law. Apply the devil's advocate theory. What if there is a central law which is violating a fundamental right? Can I challenge that central law in a High Court? Because a fundamental right can be challenged in the High Court under 226? Absolutely. The Nas Foundation case, the first ever homosexuality major judgment that actually came about in India. So this is of course wrong. An amendment to the Constitution cannot be called into question by the Supreme Court. So a constitutional amendment cannot be challenged in the Supreme Court. If that was the case, then how would the Supreme Court strike down, say, the 99th Amendment or an earlier amendment where the Prime Minister's election office, which was placed as immunity under judicial review, was struck down? That's actually not the case, because what if a constitutional amendment violates a fundamental right? Then can that amendment be challenged in the Supreme Court? Of course, that amendment can be challenged in the Supreme Court. That's absolutely no problem at all. Can you challenge? Yes, of course you can challenge. Anything can be challenged in the Supreme Court, except for, of course, orders of the Delimitation Commission and so on and so forth. But largely, yes, it can. So both the options are wrong. The correct answer is actually D. The interpretation here is CA is not law. No law can violate a fundamental right, but still, can you challenge a constitutional amendment to decide whether it is actually violating a fundamental right or not? Yes, because now the restriction is basic structure. So yeah, the answer is D, neither 1 or 2. Question number 7. With reference to the Constitution of India, prohibition or limitation provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under 142. It could mean which of the following? We have to simplify this. A. Decisions taken by the Election Commission while discharging its duties cannot be challenged in a court of law. Supreme Court is not constrained in the exercise of its powers by laws made by the Parliament. In the event of a grave financial crisis in the country, the President can declare financial emergency without the counsel from the Cabinet. The legislatures cannot make laws on certain matters without the concurrence of the union legislatures. Without the concurrence of the union legislatures, right? Now, first things first, we understand that Article 142 sort of somewhere around deals with the powers of the court. Even if you did not understand what the first statement was, you can eliminate what is incorrect from the 4 options given before you. The decisions taken by the Election Commission while discharging its duties cannot be challenged in a court of law. Why? If you're performing a quasi-judicial function, any decision can be challenged in a court of law, even if it's pertaining to decisions. This is definitely wrong. In the event of a grave financial crisis, the President can declare an emergency. No emergency can be declared without the written advice of the Cabinet. That's why, because an emergency is going to fundamentally affect center state. This is also wrong. State legislatures cannot make laws on certain matters without the concurrence of the union legislature. That's also not the case. If there is something in the state list, the state legislatures are free to make a law no matter what the case might be. What are you left with? The Supreme Court is not constrained in its exercise of powers of laws made by the Parliament. This is the extraordinary power of the Supreme Court, that in the interest of justice, the Supreme Court can pass any judgment that it feels is appropriate. The plenary jurisdiction that we've also discussed in our lecture on judiciary in the Magna Carta, I sincerely request, in case you haven't, you should watch it for a quick revision. The answer would be B. Next, consider the following statements. The motion to impeach a judge of the Supreme Court, the motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker as per the Judges Inquiry Act 1968. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court. The details of the process of the impeachment of the judges of the Supreme Court are given in the Inquiry Act of 1968. If the motion of the impeachment is taken up for voting, the law requires the motion to be backed by each houses of the Parliament and supported by a majority of the total membership and by not less than 2/3 of the members of each house present and voting. All right. Now let's see the option combos: 1 and 2, 3 only, 3 and 4, 1, 2 and 4. All right. So there is 3 mentioned in 3 out of 4 options. The details of the process are mentioned in the Inquiry Act. Seems to be correct. Let us see if we can eliminate something. We can definitely eliminate the second option. The Constitution defines and gives you what the meaning of proved misbehavior and incapacity is, or incapacity and proved misbehavior is, largely because there is no way you can define something so vague. Tomorrow some new instance will come up and that will may or may not be incapacity or proved misbehavior, and the Constitution would be very narrowed in that element, and it would then also limit the powers of the Parliament to then decide on a case-to-case basis whether something is truly falling under these grounds or not. So the second option is incorrect, and because the second option is incorrect, this is obviously not to be considered, right? Now look at the other options. You've got 3 only, 3 and 4, and 1, 3 and 4, which means the details are given for sure. So that is absolutely correct, which means 3 is definitely correct no matter what. If the details are correct, that is absolutely okay. This is special majority 2. 3 and 4 is definitely correct no matter what. 3 and 4 is definitely correct no matter what. Now look at the first option, right? The motion to impeach a judge of the Supreme Court cannot be rejected. Now think about it. If one person has a grudge against a Supreme Court judge and they say that the Supreme Court judge has to be removed, and this one person happens to be an MP, don't you think you're wasting precious time of the Parliament? So in that case, the Speaker can reject this motion. Of course you can reject the motion. So this is incorrect. The option will be C, 3 and 4. Just apply it to a practical circumstance and you will know your answer. Okay, the answer is C. Consider the following statements. Sounds like a tough question, but actually is not. The Petroleum and Natural Gas Regulatory Board is the first regulatory board set up by the Government of India. One of the tasks of the Petroleum and Natural Gas Regulatory Board is to ensure competitive markets for gas. Appeals against the Petroleum Gas Regulatory Board go before the appellate tribunals for electricity. Go before the appellate tribunals for electricity, right? Which of the following options is correct? Okay. Now, most of us will have no clue about what the regulatory board does. Let us see the options. We've got 1 in 3 options, we've got 2 in 3 options, and we've got 3 in 3 options. So option combinations might not work. It is the first regulatory body set up by the Government of India. Isn't RBI also a regulatory body? It regulates the banks. Isn't the Securities and Exchange Board of India also a regulatory body? Isn't the Insurance Regulatory Development Authority also a regulatory body? So are you really saying that this was the Petroleum and Natural Gas Regulatory Board was set up before the RBI was? No. So any option which has 1 in it automatically gets eliminated. The answer is B, 2 and 3. A simple question if you just focus on one of the words which is mentioned in the question. Next, again can be done through a simple logical elimination. How is the National Green Tribunal different from the Central Pollution Control Board? A very good question actually. The NGT has been established by an act, whereas the Central Pollution Board has been created by an executive order of the government. The NGT provides environmental justice and helps reduce the burden of litigation, while the Central Pollution Control Board uh, promotes cleanliness of streams and wells and aims to improve the quality of air in the country. All right, fair enough. Which of the following statements are correct? See, this is factual, so you may or may not know whether the Central Pollution Control Board was set up by an executive order or not. NGT is a tribunal. Tribunals have to be authorized by an act because these are judicial bodies. They will not have the powers to adjudicate otherwise. So the first half of it is definitely correct. The second half seems to be a problem. Now see, the question itself tells you the Pollution Control Board is supposed to promote cleanliness of streams and wells and aims to improve the quality of air in the country. Now, if you have to improve the quality of air, will you not have the powers to issue certain orders? Will you not have the powers to issue certain guidelines? Will you not have the powers to issue some form of regulatory rules and procedures? So it seems like just giving an executive order to establish a control board which is going to set up the standards of what are acceptable levels of pollution and what is not seems highly unlikely. And we anyways have a plethora of environmental laws, so this doesn't seem very likely. The functions are all right. The answer is B, one only, and not the first option. The Pollution Control Board does 10 other things, but amongst the things that it does, this is definitely correct. 11. In India, judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, the power of the judiciary to question the wisdom of the laws enacted by the legislatures, the power of the judiciary to review all the legislative enactments before they are assented by the President, the power of the judiciary to review its own judgments given in earlier or similar cases. Now, this means this is a court of record / also has limited powers of review. The power of the judiciary to review all legislative enactments before they are assented is a violation of separation of powers. The power to question the wisdom of the laws is again a violation of separation of powers. You actually cannot question legislative wisdom. The answer is A, which is to pronounce on the constitutionality of laws and orders passed. Okay. Consider the following statements. The Election Commission is a 5-member body. The Union Minister of Home Affairs decides the election schedule for the conduct of both general elections and by-elections. Election Commission resolves disputes relating to splits or mergers of recognized political parties. A very, very good question if you can eliminate using the using the options. All right, you've got 1 and 2, 2 only, 2 and 3, and 3 only. All right, let us see if we can eliminate. We've got option number 2 in statement number 2 in 3 places. So if we can eliminate statement number 2, the Union Ministry for Home Affairs decides the election schedule for the conduct of elections, for the conduct of both general elections and by-elections. If that was the case, then would you not be encroaching on the independence of the Election Commission? Would that not therefore make sure that the elections are strategically timed by the government in power? And why would a single ministry get to decide this? If you really had to, would you not have the Ministry of Parliamentary Affairs for that matter? This anyways violates the independence of a constitutional body. So obviously the second statement is wrong. So any option which has the second statement automatically goes wrong. The answer therefore happens to be D. The Election Commission is a 3-member body, something that you anyways know. So that of course eliminates option number 1 as well. Very easy question, can be done. Then question number 13. Which of the following is the custodian of the Constitution of India? This was also heavily debated because people got into, the meaning and the depth of the oath and all of those things. Custodian means somebody who protects. Protecting the Constitution from what? Laws that can violate the Constitution or attacks against the provisions of the Constitution. And who decides whether a law is valid or not? The Supreme Court does. Don't think twice about it. The answer will be the Supreme Court. The Prime Minister and the Secretariat anyways have no role to play with constitutional safeguard. There was a slight bit of debate in 2015, a heavy debate on that the oath of the President says to defend the Constitution, but this is understood in a very layman point of view, right? So this is the answer. Question number 14. The government of India has established the Niti Aayog to replace the what? The question doesn't even need the attention that it so deserves. The answer is of course D, Planning Commission, because you're moving from an executive setup of planning to an advisory setup, and the primary difference is the Niti Aayog does not get the same kind of advisory planning services, advisory financial planning services that the Planning Commission used to enjoy in its erstwhile reign. So the answer is D. The power to increase the number of judges in the Supreme Court is vested in the what? Recently increased the number of Supreme Court judges. The answer is the President, the Parliament, Chief Justice, or the Law Commission. The Law Commission is a recommendatory body. No. The increasing the number of judges would mean you will also have to increase their salaries. You'll have to pay salaries to the new judges. Salaries have to be taken out from the Consolidated Fund of India, as Supreme Court salaries are charged there, and any money taken out from the CFI will require a parliamentary approval, and therefore in fact this is nothing but a financial bill, and the Parliament therefore has the powers to decide. So we've got the Supreme Court Number of Judges Act also. So the answer is B, the Parliament. The power of the Supreme Court to decide disputes between the centre and the states lies in what? Which means what kind of jurisdiction is this? Advisory, appellate, original, or writ? So obviously this is where you are hearing the case for the first time. So the answer will of course be original jurisdiction, because it is only and only the Supreme Court that can hear centre-state disputes. The answer is C, original jurisdiction, right? 17. Which of the following bodies do not find mention in the Constitution? NDC, Planning Commission, and Zonal Councils. This is a good question for 2013 because a lot of reshuffling of bodies was happening around that time, but you can still solve this question through a simple elimination method as well, right? Which of the following are not? NDC, Planning Commission, and Zonal Councils. 1 and 2, 2 only, 1 and 3, 1, 2 and 3. So we can see that 1 is in all the 3 options. So is National Development Council a constitutional body? No. It was essentially set up and the leader of the government party was made a key position holder here. This is definitely true. It is definitely not a constitutional body. Planning Commission is definitely not. So 1 and 2 is definitely correct. Zonal councils are also not. Interstate councils are. Therefore, the answer is D, 1, 2 and 3. Neither of them are actually constitutional bodies because they're not performing any such function. I don't think even interstate councils are. They're also set up under the Reorganization Act. Now, consider the following statements with respect to Attorney General. An Attorney General can take part in the proceedings of the Lok Sabha, be a member of the committee of the Lok Sabha, speak in the Lok Sabha, and vote in the Lok Sabha. Was a tricky question, but actually can be solved very easily. Which of the following statements are correct? To take part in the proceedings, to be a member, to speak in the Lok Sabha, and to vote in the Lok Sabha. What we know for sure is Attorney General, rule number 1, democratic mandate, is an appointed office and not an elected office, is not a member of the Lok Sabha. So if you're not a member, you cannot vote. So so this means that option number B is out. Now you only have to look at whether 1, 2 and 3 and 1 and 3 is correct. That means 1 is definitely correct. You definitely can take part in the proceedings of the House. Now, if you can take part, that means you can also speak. That is how you take part in the proceedings. 1 and 3 are supplementary. So 1 is out. So it's either figuring out whether you can be a member of a parliamentary committee comprising of the Lok Sabha or not. Now that becomes the tough part. Can the Attorney General be a part of a parliamentary committee or not? Now, does the parliamentary committee actually vote substantially on something? No. Is the parliamentary committee recommendatory in nature? Yes. Does it also have experts that can be invited to be members of it? Yes. So the answer would be C, 1, 2 and 3. Which among the following constitute the National Development Council? 1. Prime Minister. 2. Finance Minister, Chairman Finance Commission. 3. Ministers of the Union Cabinet. D. Chief Ministers of the State. This is a relevant question because it gets almost defunct a year later. Select the correct options from below. Now, see. The National Development Council, which means you're looking at an overall national development. So the Prime Minister, Chairman of the Finance Commission and Ministers of the Union Cabinet. See how you can answer this question absolutely clearly. Okay, see. This is the council which comprises of developmental agendas. Finance Commission largely looks at distribution of taxes and recommends on the distribution of taxes. If you see, definitely Finance Commission cannot be a member of the National Development Council. You eliminate option number 2. Anything which has option number 2 gets eliminated. The option that you are left with is B, which is 1, 3 and 4. 20. Consider the following statements again, but NDC. NDC is an organ of the Planning Commission. The economic and social planning is kept in the concurrent list of the Constitution of India. The Constitution of India prescribes that Panchayat should be assigned the task of preparation of plans for economic development and social justice. 1, 2 and 3, 1 and 3, 1, 2 and 3. We've got 1 in 3 places and 3 in 3 places. Can we eliminate? Look at the first option. NDC is an organ of the Planning Commission. If NDC is the organ of the Planning Commission and is to be headed by the Prime Minister, and the Planning Commission works under the Prime Minister and is supposed to work under the larger leadership of it, how can you have the head of the Prime Minister be an organ of an office which is under the Prime Minister? This is the incorrect option. So if this is the incorrect option, then eliminate anything which has statement number 1 in it. What you're left with is option B, which is statement 2 and statement 3. Your answer according to me should be B. Yeah. Which of the following is to safeguard the autonomy of the Supreme Court of India? While appointing Supreme Court judges, the President has to consult the Chief Justice of India. The Supreme Court judges can be removed by the Chief Justice of India only. The salaries, the salaries of the judges are charged to the Consolidated Fund of India, which the legislature does not have to vote. The appointment of the officers and staff of the Supreme Court are made by the government only after consulting the Chief Justice of India. All right, only after consulting the Chief Justice of India. Let us see what we can eliminate. Our option choices are 1 and 3, 3 and 4, 4 only, 1, 2, 3 and 4. We can see that 1, 3 and 4 find mention in 3 places. Let's see if there's something that we can eliminate. The one thing that we know is this violates checks and balances, rule number 4 of our golden rules. Supreme Court judges are actually removed by the Parliament. So anything which has 2 gets eliminated. Now we have 1 and 3, 3 and 4 and 4 only. So you have either 3 or 4 which is correct, or you have only 4 correct and 1 of course. While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. The salaries are charged to the CFI, which is true, and what is charged to the CFI is not put to vote. It is assumed to be passed under ordinary circumstances because it is needed for the efficient functioning of certain key agencies to maintain democratic balance. So 1 and 3 is definitely correct. There's no other option apart from this. All appointments of officers and staff to the Supreme Court are made by the government only after consulting the Chief Justice of India. Now think about this. This would violate what is called intra separation of powers. If the Supreme Court has to recruit officers to work and aid the Supreme Court will recruit them. The Parliament does not have to do anything with respect to that. It would violate the functioning of the agency, and the courts have their own mechanisms provided to recruit their own officers to assist them in the administration of the court. The fourth option is of course wrong, and therefore the answer becomes what is called A, 1 and 3. Next. Which of the following are included in the original jurisdiction of the Supreme Court? A dispute between Government of India or one or more states, a dispute between elections to either house of the Parliament or that of the legislature, a dispute between the Government of India and a union territory, and a dispute between two or more states. Now, this is a dead easy question. So, a dispute between the center and the states or between two or more states is original jurisdiction. Let us see what we can eliminate. 1 and 2, 2 and 3, 1 and 4, 3 and 4. A dispute regarding elections to either house is an election petition and can only be filed in the High Court. So any option which has 2 in it gets eliminated. Now you're left with 1 and 4 and 3 and 4, which means either 1 is correct or 3 is correct. The union territory is nothing but an administrative extension of the central government. So 3 is incorrect. There is no original jurisdiction here. In some cases, it gets referred to the concerned High Court, and therefore the answer becomes 1 and 4 only, which is option number C. Let's check what the answer is. I think it's C only. Yeah. With reference to the Delimitation Commission, consider the following statements. The orders of the Delimitation Commission cannot be challenged in a court of law. When the orders of the Delimitation Commission are led before the Lok Sabha or the Legislative Assembly, they cannot affect any modifications in those orders, right? So first, the orders of the Delimitation Commission cannot be challenged in a court of law. This is true because delimitation reorganizes the geographical boundaries of a constituency based on population changes, and the elections have not happened yet. So it would be a violation of separation of powers. This is absolutely correct. Now the Delimitation Commission is supposed to be independent. If the legislatures could amend the orders of the Delimitation Commission, then you would make sure that the constituencies are drawn in a certain way that each constituency has a majority voting population that will vote the party back in power in the next elections. So both of the options are actually correct. The answer should be C, a simple devil's advocate theory and separation of powers. In India, other than ensuring public funds are used efficiently and for intended purpose, what is the importance of the office of the CAG? CAG exercises exchequer control on behalf of the Parliament, and when the President of India declares national emergency or financial emergency, the CAG reports on the execution of projects or programs by the ministries and discussed by the Public Accounts Committee. Information from CAG reports can be used by investigating agencies to press charges against those who have violated the law while managing public finances. While dealing with audit and accounting of government companies, CAG has certain judicial powers. CAG has certain judicial powers for prosecuting those who violate the law. Right, got 1, 3 and 4, 2 and 2 only, 2 and 3, and 1, 2, 3 and 4. Right. We can see 3 in 2 and 3 in 3 out of the 4 options. CAG reports on execution of projects that are discussed by the Public Accounts Committee. This seems to be the correct option. Information from CAG can be used by investigating agencies. All right, now think about it. Option number 3 and 4 seem to slightly be contradictory. If information from CAG can be used by investigating agencies to press charges, and CAG also has judicial powers to prosecute, if you are the one helping people gather evidence and you're also the one giving a judicial decision, isn't that contradictory in the first place? So between 3 and 4, only one can be correct, and therefore between 3 and 4, it seems that 3 is a better option. There we go. So 4 is incorrect. So anything which has 4 in it gets eliminated, and 2 and 3 are correct options. So the answer should be C, 2 and 3. With reference to the Finance Commission of India, which of the following statements is correct? It encourages the inflow of foreign capital for infrastructure development. It facilitates the proper distribution of finances amongst public sector undertakings. It ensures transparency in financial administration. None of the statements A, B, and C is correct in the given context. So D is nothing but none of the above. So let us see what the option is. It encourages the inflow of foreign capital for infrastructure development. Why would you set up a constitutional body for this? Facilitates proper distribution of finances. Then what would the CAG do? Ensures transparency in financial administration. Isn't that the job of the bureaucracy and of course the accounting services? So none of the options are correct. The answer should be D in this statement, right? So your answer is D. Let's quickly check it. Yes. And this covers all the questions that have been asked in polity ever. As you can see, very limited areas are actually asked in the prelims. Prepare these areas well. I will see you very soon with the prelims talk. I will release it tonight itself. Thank you. Have a great day.